Please be seated. Good morning. Today we're going to hear the cases in the order as they appear on the calendar. After the first case, we're going to take a break, take a short recess to reconfigure the panel. And during that time, we're going to have coffee available in the Commons if you'd like to join us for coffee. So are the council prepared on the first case? You may proceed. I'm assuming that all council has had the operation of our clock explained to them, so we're comfortable there. I'll try not to interrupt.
Okay, please the court. Counsel. My name is Timothy Atkinson with the firm of Ortel, Fernandez, Cole & Bryant, and along with my co-counsel, Mr. Gavin Burgess, we represent appellant Ronny Goodson in a case where the Florida Real Estate Commission imposed penalties on appellant Goodson. The central question in this...
Counsel, would you like to reserve time for rebuttal?
Yes, sir. I would like to reserve 5 minutes. Thank you. The central issue in this appeal is whether the Florida Real Estate Commission erred by failing to follow Section 455.225 (5) Florida statutes, which compels the Commission to terminate the informal hearing that was conducted below so that a formal hearing will be held once disputed issues of fact were raised by appellant Goodson during the hearing. Here, the Real Estate Commission erred and the final order should be reversed. Appellant Goodson is entitled to his day in court to litigate the disputed issues of fact.
Counsel, was this issue preserved below? I'm not talking about waiver here. Right. I'm talking about the regular old preservation of error in the trial tribunal.
Well, in this case, the issue was never actually raised below. I can tell you that, but we don't believe it had to be. The appellant, once the statute is mandatory, Section 455.225 (5) states, if any party raises an issue of disputed fact during an informal hearing, the hearing shall be terminated, and a formal hearing pursuant to Chapter 120 shall be held. This statute is... So
your point is this, as a matter of law,
yes,
this statute cannot be waived.
This cannot be waived.
Fundamental error doesn't have to be preserved.
Exactly. That's our position.
And the appellant was proceeding pro se in the proceedings below. Is that correct?
That is correct. He showed up without counsel. And a respondent has said, well, that's, his own choice, but certainly he is not aware of this statute. He's not an expert in administrative law, and as I'm going to go through here, hopefully I can demonstrate that he was raising fundamental disputed issues of material fact. And this statute, 455.225 (5), is particular to DBPR licensed disciplinary cases. While a Section 120.57 proceeding could be waived, in fact, the statute says, unless waived by all parties, subsection 1 applies whenever the proceeding involves the disputed issues of material fact, parties might actually waive their right to a formal hearing under 120.57. However, where you have this particular statute that's mandatory, and the legislature is saying very clearly, if you raise disputed issues of fact during this hearing, there is no other choice but that the hearing must be adjourned in favor of a formal hearing. Now, that's exactly what happened in the Walker versus DBPR case, but in Walker, they raised no disputed facts, and Walker waived her right to a hearing. 455.225 (5) wasn't even discussed. Now, 455.
But the holding in Walker, while the court there says there were no disputed facts, the holding in Walker on the waiver issue they don't talk about the fact that there were no disputed facts. They just said it was waived.
Well, they said it was waived, but 455.225 (5) is not at play. They don't even discuss the statute. And this statute is clearly applicable to this case because this statute applies to DBPR and the boards under its jurisdiction.
Was the statute in effect at the time of Walker?
I don't know the answer to that. I think it might have been, but, maybe the parties just missed it. It's hard to know what they were doing in that case. And like I said, this is not a discretionary statute. It's mandatory. Now, I can show you below where there are several instances where appellant Goodson disputed material facts. The first thing that happened is that the commission considered at this informal hearing a written investigative report starts at Record 1, page 26. And clearly they considered it. Vice Chair Ellis of the Real Estate Commission at Record 2, page 6, says that he has read this report and they're considering it. In that report, it states at page 27 of the record, Ronny Goodson claimed that Ms. Thompson told him that the garage was part of his commission. Goodson claimed he took a reduced commission and made an agreement to accept the garage as part of that commission. Goodson stated that because he does not own a condo in the complex, he could not place his name on the garage deed. Goodson stated that his brother has a condominium in the complex, so Goodson placed the garage deed in his brother Roy's name. At Record 1, page 29, Goodson claimed that he accepted a reduced commission in exchange for space 27. At page 30, Goodson states that at the onset of the contract negotiations, he and Thompson had discussed that Goodson would get the garage in return for a reduced commission for the sale of Thompson's condo. Goodson stated that it was a verbal agreement between he and Thompson. Goodson stated that the buyer, King, told Goodson that he, King, could not afford a garage. And then later, Goodson reiterates that King stated he couldn't afford a garage.
Well, counsel, if that's all true, why did he substitute the deed, the Exhibit 4, attached to the administrative complaint?
Because
why wasn't it all out in the open in the transaction?
Well, he believed it was all out in the open, and when Thompson complained, he did like most other people do. When somebody's complaining and you think you might get in trouble, he says, well, I'm going to just make her happy and you can have it. I don't want to go through this hassle, is what he was saying. And so that's what the record investigative report shows.
Well,
so
the Exhibit 4 to the complaint is the substitute deed where he puts his brother's name on the garage unit, right?
Exactly.
Why wasn't that in the contract? I looked at the contract that he negotiated between the seller and the buyer. His commission's 5%. There's no mention of the garage unit in that real estate contract and in the first warranty deed, right?
These are undisputed facts. I can tell you that Commissioner Vesey at the commission below asked the same question. He says, well, how did it happen? If it is legal, why wasn't it in writing? And Goodson says, well, that was my mistake. Clearly, his testimony below at the commission, under oath, he is saying that all the parties knew about this. He is saying that this was the deal. And Vice Chair Ellis asked, well, why did she file the complaint if this was the deal? And he's saying that's a mystery to me. So clearly, Goodson, through the investigative report and also his own sworn testimony below, is disputing the material allegations of the fraud and concealment charge, which is what he was charged with in count 1. So, you know, he may have made a mistake and he believed it was legal, but certainly the facts are that he was disputing this fraud and concealment charge. And you could further see that through other Florida Real Estate Commission members' discussions with him. Vice Chair Ellis says, well, why did she file a complaint? Goodson states, well, that's a mystery to me. And what he's saying there is he had just explained that, well, the buyer couldn't afford the down payment. And so he is saying that all the parties knew that this was the deal. He's disputing the facts of the complaint.
Well, counsel, these questions and answers are helpful. I think it leads us back to your fundamental argument, which is that preservation is not required. And I want to ask you a couple questions about that, if I may, and the consequences if we were to rule in your favor.
Okay.
That would mean, let's take this case as an example. The commission has to make a determination in every informal hearing where a person walks in, voluntarily chooses to be unrepresented, perhaps engages in some rambling answers as the state has characterized some of his answers. They then have to make a determination, well, are these material issues of disputed fact? Perhaps your client made a strategic decision to waive, or excuse me, to request an informal hearing. He didn't want an ALJ perhaps to engage in fact-finding. But your argument is that statute places the entire burden on the agency to constantly be sorting through these types of hearings, whether or not a material fact arises in dispute.
That's exactly what I'm saying. And I could respond to you, and it's a really great question, because If you look at 455-225, again, it states if any party raises an issue of disputed fact during the hearing shall be terminated. It's a mandatory statute. In the Thompson versus DBPR case, counsel there was warning the license holder that was being disciplined, hey, if you continue to dispute facts, we're going to have to adjourn this informal hearing in favor of a formal hearing. But Thompson there, Dr. Thompson, reiterated his desire to keep going with an informal hearing. So I believe that the counsel in Thompson did the right thing. And, you know, I can tell you, if you look at the record, you can see that DBPR had no less than 6 counsel at this meeting. And so, you know, the commission, they're not spring chickens. They listen to these things. I think they have a duty and an obligation to listen to what the license holder is testifying to see are disputed issues of material fact coming up in this case, because the statute says if that happens, it compels a certain action, and that is that the hearing must be adjourned.
So you think the intent of that section then is to abrogate the contemporaneous objection rule, eliminate the entire obligation of one party to the proceeding, the licensee, from any obligation to raise an objection to assert that there's a disputed issue of fact, right?
Well, he's actually, you can see in this testimony as an example, he is actually raising disputed issues of material fact, material to the charge of concealment and fraud. So in this case, you know, Appellant Goodson has no authority or no ability to terminate this hearing. Only the agency can do that. So he could, I guess, say, well, I've disputed these facts, I'm going to walk out the door, but that's not going to really get anywhere, and it's going to be disrespectful to the commission.
Counsel,
so only the commission can do that.
Once the administrative complaint is filed, and in this case the appellant admits to the facts, statement of facts in that complaint, regardless of what they are, and at that point the only issue that's left is mitigation for the purposes of an informal hearing. Is that correct?
No, I disagree with that, because here, as an example, Goodson, he's disputing the elements of the underlying fundamental charge of fraud and concealment. And so at that point, you don't even need to get the issue of mitigation. But certainly, as you go through an informal hearing, mitigation and a penalty are proper issues for an informal hearing. I don't dispute that.
During the informal hearing, at that point, the appellant says, wait a minute, there are some issues of fact, or by inference states there are issues of fact. Why shouldn't the burden be on the appellant at that time to say, wait, hold on a second, I now want a formal hearing, rather than to resolve these issues of fact, but they're now issues of fact.
I hear what you're saying. I believe it's because...
Shouldn't he have done something? Yes,
Section 455-225, paren 5, is just simply a mandatory statute. It requires, if this happens, which is disputed issues arise, then it must be adjourned in favor of a formal hearing. It doesn't say that the appellant, the license holder has to say, hey, hold on, I'm waiving disputed issues, I'm raising disputed issues of fact, I no longer want this informal, I want to go to a formal. It doesn't say that.
Counsel, you're well into your rebuttal time.
Okay, thank you.
May it please the Court, Counsel. My name is Jennifer Cheddar, and I'm here today on behalf of the State of Florida Division of Real Estate. The Division today urges this Court to affirm the final order of discipline issued in this case because it's based on competent substantial evidence in the record, and the informal hearing conducted by the Commission in this case was not an abuse of discretion. I'd like to first start just to clear up a matter in the briefs, the standard of review for the issues that are presented to the panel today. There's really 2 issues. Was the informal hearing properly held? And the other issue presented by the briefs, which we haven't gotten into yet on oral argument, is whether the administrative complaint alleges sufficient facts to support a violation of certain provisions of Chapter 475, Part 1. The Department would like to just note that the standard of review is not de novo, in our opinion. It's been suggested by appellant that the standard of review in both cases should be de novo, but in this case, the decision by the Florida Real Estate Commission whether to convert or not convert the informal hearing to a formal hearing in front of an ALJ, it should be judged on an abuse of discretion standard. Statutorily,
Since the licensee was appearing pro se, shouldn't he have been given some leeway by the commission in this regard?
respectfully no, Judge Lewis. The commission, in the division's opinion, has taken great steps to advise everyone of their legal rights in these matters. And in fact, the record on page 3 is the first step that the division takes in advising any respondent in these cases that they may be subject to discipline and what their legal rights are. You don't need a lawyer to interpret the division's election of rights form. It's really straightforward. It tells you that when you get this 5-page administrative complaint via certified mail, you have 2 choices. They're very clearly spelled out. The ramifications of those choices are very clearly spelled out. You can either check box 1 and say, I plead guilty to all the facts, all the allegations of fraud, all the allegations of wrongdoing, kickbacks, failure to make proper disclosures. You can check, I plead guilty, but I want to at least show up and present evidence and mitigation. The language used in the election of rights form isn't difficult to understand. When the appellant got the administrative complaint in the mail, Your Honor, he had the choice to hire an attorney at that time. He mentioned that during the transcript of the hearing, he mentioned that he contacted an attorney right after the Thompsons called him to say, how could I have done this better? Did I do something wrong? Yet when he gets a 5-page administrative complaint by his licensing agency by certified mail, he apparently doesn't consult a lawyer then. He pleads guilty, goes to a notary, signs it in front of them, and sends it back to his licensing entity. Then he also made the decision. He was advised in the notice of hearing, you're welcome to bring counsel with you. That's also in the record on page 1. You're welcome to bring a lawyer with you. He again chose not to. Yes.
Assuming that you're correct and the standard of review is competent substantial evidence, would you agree with your opposing counsel that 455 imposes a statutory obligation on the agency when it and if it determines a disputed issue of material fact arises to convert the hearing, assuming you would then argue that's based on competent substantial evidence? In other words, if there's CSE to find in the agency's view that a disputed issue arises, do you agree with your opposing counsel there's no contemporaneous objection required, there's no preservation required, it's just a matter of us looking at your agency's actions and determining if there's competent substantial evidence to support its finding that no disputed issue of material fact arises?
I agree that there may be a case, I don't mean to sound ambivalent, but I agree that there may be a case where the factual dispute is so apparent that there is not one person in the room, no reasonable judge, jury, or anybody could say this isn't a disputed fact. And in those cases, I think there can be an affirmative obligation on the commission for people who are unrepresented by counsel. Certainly, Judge Lewis, we tried to give those folks a little more leeway. There may be that situation. But as you aptly pointed out, the logical consequences of the commission having to be vigilant at every turn, the prosecutors having to be vigilant at every turn, and making every decision by the commission susceptible to a reading of the transcript by appellate counsel later and determining that this happens to be a disputed fact, is really heading down a bad path for all of us. And that's the kind of thing that the Fifth Circuit warned against in Walker. This is a re-adjudication of something that's already been decided. It's a frustration of the process.
But isn't that what the statute says? I mean,
actually,
verbatim, that you shall terminate, your agency shall terminate the hearing if a disputed issue arises.
Respectfully, Judge Thomas, it doesn't require the agency to do that. A close reading of Section 455, 225, sub 5 suggests that the hearing shall be terminated. Admittedly, the commission is the one that would adjourn that hearing and set the matter then for a DOA proceeding typically. But at any point, if the appellant were to say, I don't agree with that, that's not true, I disagree with the charges of the administrative complaint, any of that language, or I want a hearing before a judge, this is a sham, I don't want to be here, any of that would have gotten him to DOA. But instead, that's not what happened in this case, Your Honor. This is the bad case to decide that on, because in this case, he was told what he did wrong and pled guilty. Specifically, marked the box that says, I agree. Everything that you accuse me of, I agree I did. Signed that in front of a notary and sent it back. The other thing that I'd like to at least point the court to is this. The way to determine whether a disputed fact actually arose in this case is best done by looking at the charges of the administrative complaint, because that's what he has admitted to, according to his election of rights form. Compare that to the transcript. The key findings in the administrative complaint are on page 5 and 6. Judge Thomas, you hit the nail on the head when you alluded to the fact that the issue in this case is, did the appellant substitute a warranty deed for his brother in place of the buyer without consent? That's the factual allegation in the complaint that got the appellant in so much trouble in this case. Did he put a different warranty deed in when the addendum to the contract couldn't be more clear? It's on page 18 of the record. It's only got 3 points and about 12 words. It says, number 27, parking space and 5% commission. So it's very clear from the purchase and sale contract that's what was supposed to happen. And the administrative complaint charges him with substituting a warranty deed. There's not one thing in the transcript of this proceeding that appellant says that disputes the fact that he substituted a warranty deed of his brother without consent.
But doesn't the testimony indicate that he's contending that there was, in essence, a verbal amendment to the agreement that would allow him to receive the parking space in lieu of a commission?
Respectfully, Your Honor, I don't read it that way. He makes there's some statements in there about, I thought this was what we were all going to do. He couldn't get financing, but they are not well articulated, and they certainly don't, in the division's opinion, arise to the level of a dispute of that fact, that he substituted a warranty deed without consent. His brother doesn't even come up during the hearing. We don't even talk about him. And that's purportedly the fact at dispute. The rest of the facts aren't even discussed.
Counsel, I'm intrigued by your interpretation of subsection 5. If I understood what you said, is that the agency only has a requirement to terminate the informal hearing and start and institute or transfer it to the Division of Administrative Hearings if no reasonable person would not find that there's a disputed fact. There's such a dispute that it's obvious to everyone. Now, how is that a fair reading of what the legislature says? Because it's one thing for the legislature to say that where there's a disputed issue of fact, a formal hearing before DOA shall be held. That's the first sentence of 5. But then they said if any party raises an issue of disputed fact during an informal hearing, the hearing shall be terminated. Now, if I'm a strict constructionist, and that's what the legislature says, why don't we take them at their word? And if it's a problem for the agencies, the legislature can fix it.
Respectfully, Your Honor, I didn't mean to state that that would be the only circumstance. It was certainly, in response to Judge Thomas's question, a circumstance would arise.
That's your standard of review issue, I understand.
Yes, and certainly, Chapter 455, the Department is entitled to at least some deference in its interpretation of what is required under that statute for us. There is no, in the Department's estimation, affirmative obligation on the Department to be the protector of formal hearings for anyone and everyone who doesn't specifically say at least something about disputing a fact that's at issue by the administrative complaint. But there certainly, I think there would be cases where people show up and they may have checked the wrong box. I didn't mean to be here. I didn't know that's what I was doing, and that would be a case where, as Judge Lewis noted, that if someone appeared without counsel and said, I didn't know what I was doing, I checked the wrong box, but everything you're saying is a lie, then absolutely, that hearing should be terminated. They virtually requested a formal hearing then in that instance and alleged error. But again, Your Honor, we must judge this case on its facts. And in this case, there was no dispute of facts. He checked the box to plead guilty to all of it, and then when he appeared at the hearing, didn't actually dispute the facts in the administrative complaint. He made some generalized comments about he thought everybody knew what was going on, which is belied totally by the terms of the addendum. There are times, certainly, Chapter 455, or Section 455, 225, sub 5, must be given effect. It means something. It's a statute. But it does not, as appellants suggest, place this very onerous burden on the agency, in our opinion, to look for disputed facts, which would then just be invite more appellate reviews such as this in cases where there simply aren't disputed facts.
Well, counsel, if we were to rule in your favor and craft a rule, write a decision interpreting that section along the lines you're presenting here today, exactly what would you propose we write in terms of how that determination is made that the hearing should be terminated? I sense that you're saying essentially that if there's some kind of mistake of fact or a person comes to the hearing under an erroneous assumption or makes a clear error on the apparent in the record, that he or she intended to dispute the facts from the very beginning, then maybe in those unusual circumstances a hearing has to be terminated. And as I tried to ask earlier, well, I'll leave it at that. I'm sorry for my long questions. What rule do you think, what standard would you enunciate for us to consider to interpret section and subsection 5?
The departments would suggest today that the court limit its holding to the facts presented to it today. There's actually PCA would be fine, Your Honor, but
Counsel,
like
that
the
was recorded,
like
so
the Fifth District
it'd
did.
be evidence that there is a lawyer in Florida who wants us to use PCA. So
Very good, Your Honor. The evidence in the standard articulated by Walker, which incidentally Judge Van Nortwick, 455-225 sub 5 was in effect at the time Walker was decided. I find it appearing in opinions as far back as Cohen in 1981. So it certainly was in effect at that time. But the notion that if you plead guilty to all the charges and then appear at a hearing and don't actually dispute the facts in the administrative complaint, hit them head on, which is the idea of substituting the warranty deed to his brother, you're not entitled to a formal hearing. That's not an abuse of the Commission's discretion. I think the Court's holding can be that narrowly limited today.
Counsel,
we will likely see this again. Yes, Judge.
The appellant was charged with at least 3 separate infractions in the administrative complaint. Is that correct?
Yes, Your Honor.
Okay. And let's assume for purposes of argument that during the informal hearing, the appellant raised a question of fact regarding only one of the 3 separate infractions.
Yes, Your Honor.
Does it make any difference as to whether or not he would be entitled to a formal hearing? At that point, could the Commission have made its decision based on a violation of the 2 remaining infractions?
I think that the prosecutor would have the discretion at that informal hearing to dismiss that count, and that we've certainly seen that on occasion where, okay, you want to argue about that one, but you're definitely guilty of the other 2. You can't deny that. And that could be what happens in that case, but and that'd be my guess as to what would typically happen often. But yeah, they would, if they dispute the facts and it's all in the AC, then they would be entitled to a formal hearing.
But it's so for sake of argument that he did not get his formal hearing in regards to the question of fact involving the 3rd infraction. Could the Commission be affirmed regarding the other 2?
Yes, Your Honor, and if I may answer, I see I'm out of time. Yes, Your Honor, in this circumstance, let's say that the one violation for which he wasn't afforded, the only one for which he could have been afforded a formal hearing, if the penalties imposed by the other 2 would result in revocation regardless, then it's form over substance to give him a formal hearing on an issue, let's say a disclosure issue or something like that, that would carry 1,000.
How does this court know that the commission would have reached the same result involving the other two as it reached involving all three this time?
Because the counts are judged independently and discipline meted out. So we would hope that the court would have that. I mean, the commission would judge the counts, the two counts, carry with them a corresponding disciplinary guideline that specifically spells out what you can and cannot impose as far as discipline. And that would be true whether count one was in the complaint or not. Thank you, Your Honors.
The counsel for appellee was allowed to run over about a minute and a half, so if you could add a minute and a half to the appellant's time.
Thank you.
Please.
Now, I'd like to address this issue of, what the standard would be here if we're not going to say that if any issue of fact arises, we're going to just immediately adjourn. To me, that is the standard. If any issue of material fact arises, the commission here, the agency, must immediately adjourn the informal hearing. Why is this? Well, one reason I think is that the Florida legislature gave DBPR agencies and boards under their jurisdiction this special statute. If you had in other words, a DEP permit that was under a disciplinary case, you don't have the benefit of this 455-225. The legislature, I guess, felt that it was a public policy of the state that people that have these licenses to do business, these are professionals, they're entitled to this additional protections. And also, I would suggest that this is all in the realm of disciplinary action, and therefore it's penal in nature, and any inferences should be resolved against the agency in favor of the accused.
Counsel, let me ask a question. Refresh my memory. Did the appellant, I know the appellant told sort of his story, but did he at any point ever deny any of the allegations in the complaint, so that we can say that basically he has changed his position from when he, in effect, agreed with the allegations in the complaint?
Well, if you look at the substance of what his testimony was in front of the Real Estate Commission, he was asked by Vice Chair Ellis, so, hey, why did she file a complaint? And he's saying that's a mystery to me. So in that respect, I think after he told his story about what they were going to do, third it up, he is in effect denying the allegation directly. And, Judge Lewis, I wanted to respond to your question. What if there's only one disputed fact? I contend that 455-225 demands that any one issue of fact requires the informal hearing to be terminated. How can this court know what mitigation? The agency's rules have one of the rules that you consider in mitigation is how many counts there are. So if, let's say, this court was to throw out one count, that would only leave two counts. How is this court supposed to reweigh the evidence? I would suggest that would be folly.
Would you agree, counsel, that assuming you're right and the issue of a disputed fact, whether it arises or not, if it does arise, demands a formal hearing, we review the agency's decision in that matter by the competent substantial evidence standard?
I would disagree. I think this is a de novo standard. I look at this as a mandatory statute that has no discretion. I
understand your argument that it's a de novo standard as to whether the statute abrogates the preservation rule.
Exactly.
But I'm trying to determine how it will work in practice. If it does, and the agency has a hearing like it did in this case, and the commission's thinking there's no disputed issue of material fact here, isn't that a factual finding we review by the competent substantial evidence?
I would disagree. I still think this is de novo, and the reason is that task that the appellate court would have at this stage is very similar to what this court does when you have a motion for summary judgment. A motion for summary judgment, you're presented with transcripts in the record, and your task is to say, well, are there any disputed issues of material fact that would have to go to a fact finder? That is done by, it's clear, it's well settled that that is a de novo standard. That task is the same task you would have in this case under a mandatory statute. So I would contend it's de novo. And I think I'm out of time.
You are.
Thank you very much.
Thank you, counsel. We will take about a 10 to 15-minute break to reconstitute the panel, and you're welcome to join us for coffee in the lawyers' lounge next door. Thank you.